Olá e bom dia a todos. Estamos aqui para apresentar o nosso bate-papo com Ralf Sauer, sabendo tudo sobre as novas cláusulas contratuais padrão da Comissão Europeia para transferência de dados pessoais. Antes de tudo, é uma grande alegria termos aqui esse espaço, juntamente com o Ralf Sauer, numa promoção conjunta com a Comissão Europeia, na CPDP Latam. CPDP, original em Bruxelas, é conhecida como provavelmente o evento, a conferência mais importante e influente em proteção de dados e privacidade, e é muito significativo que a primeira edição fora de Bruxelas seja feita justamente na América Latina, que passou nos últimos tempos, nas últimas décadas, de zona de fronteira do debate regulatório de proteção de dados, para uma região na qual as legislações de proteção de dados já estão plenamente implementadas em muitos países. A discussão é muito forte, muito sensível entre reguladores, sociedades, cidadãos, empresas, e agora, nesse momento, mais que nunca, é necessário prestar muita atenção para o contexto global de transferência de dados. E, justamente para isso, temos a oportunidade de tratamento o diretor de transferência de dados e proteção de dados da Comissão Europeia e também um dos autores das novas cláusulas contratuais padrão para transferência de dados, que é o objeto da nossa conversa. Nós vamos tratar aqui hoje dos elementos-chave e dos pontos, das novidades dessas novas cláusulas. Recentemente foram lançadas essas cláusulas na sua versão modernizada pela Comissão Europeia. Vamos discutir a sua eficácia e o seu papel dentro de um contexto mais amplo de transferência de dados, que envolve também vários outros instrumentos sobre os quais também falaremos hoje. O tema é muito relevante porque no ecossistema digital de hoje, a previsibilidade, a transparência e a eficácia no sistema de proteção de dados depende muito dos elementos, instrumentos de proteção, também a nível internacional. Antes de passar aqui diretamente para o Ralf Sauer, que temos muita honra em termos aqui conosco, eu vou ler um disclaimer da instituição que hospeda o CPDP, a Fundação Getúlio Vargas, que é no seguinte sentido: as manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participem de eventos de transmissões online representam exclusivamente as opiniões de seus autores e não necessariamente a posição institucional da FGV. Reiteramos também que todos aqui presentes concordam em participar desse evento de forma espontânea e, com isso, autorizam o uso de seu nome, voz e imagem, além de ceder os direitos autorais patrimoniais relativos à sua exposição para essa transmissão que ficará nos canais oficiais da Fundação Getúlio Vargas. Para seguir com essa transmissão, pedimos que se manifestem verbalizando ou sinalizando a sua concordância. Então, agora é o momento onde damos um sinal de consentimento inequívoco à utilização dos nossos dados para os fins da conferência, exclusivamente para isso, que é um consentimento também específico, como nossas legislações, o LGPD, GDPR e tantas outras especificam, e aqui passando direto para o nosso tema. Pois é, Ralf, muito obrigado por estar aqui conosco. O Ralf, como eu já mencionei na abertura, ele, além de ser umas pessoas que certamente mais têm experiência, propriedade para tratar de qualquer tema referente à transferência internacional de dados e os aspectos internacionais da proteção de dados, ele também é um dos responsáveis pelo desenho das novas cláusulas contratuais padrão da União Europeia para transferência de dados entre países. Eu gostaria de começar propondo uma pergunta mais geral, Ralf, no sentido que você me diga: Ralf, você podia contar para o nossa plateia quem é você, qual a sua experiência na área e também o que são essas tais cláusulas contratuais padrão e qual o papel que você teve na sua definição, no seu desenho?
Yes, can you hear me? I need a thumbs up maybe from your side on this. Okay, perfect. Well, first of all, great, Daniel, to see you again. It's always a pleasure. and many thanks for the invitation for this CPTB letter event. On my person, I'm co-leading the department in the European Commission, which is the executive arm of the European Union, if you wish. I'm leading a department which deals with the international aspects of data protection. So it has a double objective to facilitate the flow of personal data, while at the same time ensuring that when data is transferred across borders, that it is appropriately protected, that there are guarantees for data protection in place. And indeed, within this context, we cover many different tools for transfers, but one of the most important tools that we have under EU law is that of standard contractual clauses, and so I was indeed directly involved in the modernization and recasting of the existing model clauses. We have had standard contractual clauses for something like 10-15 years. We had different sets which were adopted at different times, but they date back to the beginning of the 2000s, and there was a need to modernize them. And so I was involved in, first of all, the preparation of this work, because we did a lot of outreach to stakeholders. We consulted companies and trade associations to, first of all, get an idea of what needed to be changed, what were the expectations of those that apply the so-called SCCs. Then I was involved in the drafting of the clauses in the first draft, which then went through public consultation. Was then also participating in the discussions that we had with our data protection authorities as well as other stakeholders. We received a lot of input from stakeholders in the public consultation, and then on that basis, together with colleagues, obviously, we revised those clauses and carried them through the process. So basically, from start to end. Again, this is obviously never the work just of one person. So it was a co-production with some colleagues, but I was leading that effort. Yes.
Muito obrigado, Ralf. E nesse sentido, eu gostaria de, antes de perguntar com mais detalhes alguns aspectos dos contratos padrão, cuja participação no desenho acabou de nos colocar aqui, eu gostaria de dar um passo, talvez um pouquinho, para antes das cláusulas contratuais somente, e pedir a você, por favor, para até colocar para a gente, para a plateia, um posicionamento sobre quais são os elementos que hoje em dia garantem a transferência internacional de dados, entre países, segundo o GDPR, quais são aqueles que você vê como os mais importantes, os mais utilizados, e porque não são somente as cláusulas contratuais padrão que vão fazer esse papel, mas elas vão ter um papel muito importante nesse esquema, que é composto por outros instrumentos. Por favor, puder passar para a gente uma ideia de quais são esses outros instrumentos e quanto eles são importantes na visão de vocês que trabalham primordialmente com o tema da transferência internacional.
Yes, I mean that's indeed an important point to make, that these standard contractual clauses, these model clauses, are probably the most important tool in terms of the volume of data that are transferred. It's difficult to estimate. Those that have tried to do so have come up with figures around, I don't know, 80–85% of data transfers are based on these model clauses. But alongside those, there are indeed other important tools. The General Data Protection Regulation, which is the EU data protection framework, and in short, the GDPR, has we always say a broad toolbox of instruments that can be used for data transfers, which I think fall generally into three boxes. There is what we call so-called adequacy findings or adequacy decisions. Then we have tools which are there to ensure appropriate safeguards, and they are mostly contractual tools, but there are also, for instance, the so-called binding corporate rules. So those are binding intra-group rules that need to get approved, that don't necessarily have to be contractual, as long as it's ensured that they are binding within a corporate structure. And then as part of appropriate safeguards, we also have certification mechanisms, approved certification mechanisms, or approved code of conducts can also be a transfer instrument. I will say a bit on each of those, but just to give you the overview. So that's the second box, which we call appropriate data protection safeguards instruments. And then we have a number of statutory grounds for data transfers. So they don't need to be further developed. They are laid down already in the law. So for instance, the possibility to transfer data on the basis of explicit consent, or where a transfer is necessary to fulfill a contract, for instance, that those are important ones, or for important public interest grounds. So those are already directly in the law, although they have been further clarified and specified in guidance that exists on these statutory grounds. So if one wants to understand those, one needs to read them together with guidance from the European Data Protection Board, which provide more detail. But coming back to perhaps to adequacy for a moment, because that is also, I would say, that's the other very important tool that we have in our toolbox. An adequacy finding is basically a finding of equivalence. So it's not an international agreement. It's a unilateral decision, but it's a declaratory decision. So it's a decision which is based on an assessment of the legal regime of a third country, in particular the data protection rules, and it compares those rules to the rules that we have in Europe. The requirement is not that these rules are identical, but they have to ensure an equivalent level of protection. And when that is the case, then we can, and we do this, of course, only on request. If a third country asks us to do that, we can then declare that data protection regime as equivalent and to ours, and therefore as adequate. And that then allows the free flow of personal data to that third country, and in its totality, if it's an adequacy finding for the whole country. So you then don't need any further transfer instrument. There's no need for any further authorization or anything else. In a way, the third country is then treated as if it was part of the EU internal market. So it's for the purposes of data protection. So data can go without any further transfer tool. And so the other one maybe where it's worth spending a moment, or the other two important tools are binding next to model clauses, which we will discuss, but then there are binding corporate rules. I mentioned that earlier. So they are usually drawn up by the corporate group itself. There's guidance as to how they should look like. And then they go through a process of assessment by the data protection authorities, which have to approve them. And then data can flow freely within a corporate group, which is of course quite important to have the exchanges within a group. And the last one I wanted to mention specifically is that of certification mechanisms. That is also something which the GDPR allows for. We are still in the preparatory phase. Some guidance is still under development, and some procedural rules are still in development. But this will also be an important tool because it will allow companies that are certified to receive data from Europe for whatever purpose. But of course, it also then means they have to be certified and to some extent monitored by a specific certification body, and they have to ensure a number of safeguards and enforceable rights. So there are certain standards that need to be fulfilled, but that is also, I think, an important tool for the future.
Muito obrigado, Ralf. É muito também relevante que a gente note que dessas ferramentas todas que o Ralf mencionou, que são muito importantes para possibilitar e legitimar a transferência internacional de dados, nós temos já presentes nas legislações latino-americanas de proteção de dados um grande número delas. Falando diretamente da nossa legislação brasileira, da minha, aliás, eu posso notar que todos os instrumentos aqui mencionados, inclusive certificação, estão presentes na LGPD como elementos capazes de legitimar a transferência internacional de dados. Agora, evidentemente, estamos com uma lei que ainda não tem nem sequer um ano de aplicação e a grande maioria, aliás, nenhum desses instrumentos ainda foi desenvolvido, mesmo porque muitos deles dependem muito da atuação regulamentar da nossa DPA, da Autoridade Nacional de Proteção de Dados, e também das provocações que serão feitas, mas certamente como o intenso trabalho da Comissão Europeia e de muitos outros atores para proporcionar um ambiente transparente e seguro para a transferência internacional de dados vem sendo um dos temas mais palpitantes, intensos, de discussões de proteção de dados nas últimas décadas. Certamente vai chegar o momento em que essa discussão também vai ganhar muito vigor, também no Brasil, na América Latina. Então, esses instrumentos estão aqui, estão presentes. Eu gostaria de fazer somente também um aviso de que estamos recebendo perguntas para serem colocadas aqui para o Ralf Sauer. Essas perguntas podem ser feitas por meio do chat no YouTube ou no outro instrumento que estiver à disposição, mas no YouTube a gente recebe e no final a gente vai ter um espaço para esse debate. E, Ralf, eu tenho, continuando com as minhas perguntas, antes que venham as do público, tendo visto esses outros instrumentos e notando que você mesmo mencionou que o grande volume de transferência de dados que vocês observam, hoje um grande volume deles é legitimado através das cláusulas contratuais padrão. Então, isso já dá uma amostra da importância fundamental, estrutural, dessas cláusulas contratuais padrão no framework, no modelo de transferência internacional para a União Europeia como um todo e no potencial que ele pode ter de desenvolvimento também em outras regiões. Eu gostaria de perguntar agora, um pouco mais de detalhamento, o que são, de fato, qual que é o conteúdo dessas cláusulas, o que elas pretendem, de fato, incorporar nos contratos que as recebem, por que elas foram objeto dessa revisão, por que houve a modernização das cláusulas contratuais padrão justamente nesse ano, e o porquê também de tanta conversa, tanto debate em torno delas.
Okay, so I will try to indeed follow the structure they have given me and first explain a bit what they are and then sort of why have they been updated and perhaps maybe also a few words about what are the benefits that I see, because they are indeed a very important tool and a very useful tool, I think, in particular for small and medium-sized companies, for any kind of company, but in particular for small companies, because they are particularly low-cost and ready-made solution, which I think is helpful for small companies. But to start with what they are, so we call them standard contractual clauses, but you can give them any kind of name. What they are model clauses. So they are pre-approved contractual clauses, only on the question of data protection, of course. So they set out data protection safeguards, certain principles, certain obligations, certain rights. They deal with related liability issues, for instance. They deal with redress and oversight. But it's just all around data protection, and they can be. And the idea is to, in a way, plug them into a commercial contract. So a commercial contract, which will of course deal with many other issues of what do you have to provide, maybe in a service contract, which kind of service do you have to provide, what is it going to cost, by which time does it have to be delivered, and so forth. And then you can have alongside this this model contract, which only deals with how will data be protected, what are the obligations of the receiving end, so what we would call the data importer, with respect to personal data that would be transferred as part of the contract, as part of the commercial relationship. And so they are. We have actually different contractual tools under GDPR. You can either draw up your own data protection safeguards as contractual clauses and get them individually approved, or and that's of course much better. We have pre-approved model clauses, so you know that if you use those, they will allow you to receive data from you. They are a transfer instrument that is recognized in EU law. So we're talking about these pre-approved clauses. That of course also means that parties cannot modify them, so they have to take them as they are. They can go beyond, they can add safeguards, but they cannot go below. They cannot change any element which would weaken them, because then you would lose the approval, the pre-approval that has been given. They create what we call third-party beneficiary rights. So to say it more simply, the individual whose data is transferred has rights under this contract, although it's a contract between two commercial operators, but they have to, as part of the contract, recognize that individuals have rights, which they can also directly enforce against the companies, in particular the data importer. So that is part of what you have to agree to as a party. And there are mechanisms of enforcement. There is a liability clause. There is a clause which requires the data importer, so the recipient of the data, to submit itself to the jurisdiction of a European data protection authority, a supervisory authority, and also to the jurisdiction of national courts in Europe. So that's important because, of course, the individual whose data will be transferred sits or is a resident in Europe typically, and therefore it's important that he or she can go to a local or national data protection authority and can go to a national court in case of a dispute. So there are certain elements around that to ensure that these safeguards are not just contractually agreed, but also complied with, and that there's a way to enforce them. But the core, of course, of the contractual clauses are as I said, the core data protection principles. So in terms of purpose limitation or limited retention of data, limited storage of data, data security, things like this. There are certain obligations on the parties, in particular on the data importer, for instance, in terms of transparency, so the information to be given to individuals about what's being done with the data, or in terms of data security again, or in terms of notification of data breaches. That's also an important aspect. And then there are a number of rights which are guaranteed under the contract. So, for instance, the right to access the data, of course, with certain exceptions that are possible, but in principle, the right to access the data, the right to have incorrect or incomplete data corrected, and the right to certain rights with respect to automated decision making if the data would be used for that. So that's let's say the catalog of safeguards. I think we probably will later on we might still discuss a somewhat separate aspect, which is also addressed in the clauses, which is that of government access. So the question of what the parties need to ensure or guarantee with respect to not themselves using the data, but the government, the public authorities in the third country when they request the data. So obviously that raises questions of its own, and so maybe we deal with this later. But just to say there are also a couple of rules around that particular aspect. Why were they modernized? As I said, we had already model clauses in the past, since the early 2000s. And that's in a way already part of the answer. Of course, life has changed, the economy has changed, the processing of data and the risks that we face today are not the same as what was the case 15 years ago. And so there was a need to, on the one hand, update the safeguards, sort of adapt them a bit to the new risk environment, but also to update them in the light of, let's say, the changes in the digital economy. So in particular, we have tried to make these clauses more flexible, to make it possible to cover more transfer situations than we had before, because I should have said this before, the clauses that we have now developed are modular. So they cover different types of transfer scenarios, and depending on which transfer scenario you are in, you have to pick one or the other model. So for instance, there is a difference whether data is in a way sold, and so between what we could call a controller and another controller, or whether it's rather that you have a controller processor relationship, so someone is processing the data on your behalf. That raises different questions, and therefore the clauses are different for these two types of processing scenarios, and then you can have also the reverse relationship. It could be that the data importer is actually the controller, which has first given the data to a processor in Europe, and then the data is sent back. So we're also covering that situation. There can be sub-processing. So there are a number of different scenarios which we try to address through different modules. And so this is also something where the modernization has played a role. We wanted to make sure that these various types of processing scenarios or business cases are covered. And and then last but not least, there was indeed a question what to do about government access. I mentioned that before. We had a judgment from our highest court on the question of to what extent do private parties also have to ensure that they can actually live up to their obligations when the data might be accessed by public authorities, and so we and that there's certain requirements around that which we have tried to capture in the new set of model clauses. So those were, I would say, the main motivations for modernizing them. And then perhaps a last word on, and I'm trying to be brief on this, on, again, what are the benefits of model clauses? I mean, first of all, of course, they are quite a useful tool to bridge differences which might exist between the data protection regimes of different countries. So if the country where the data exporter is in and the country where the data importer is in have different rules, in a way you can bridge over this gap through a contractual regime, because the model clauses create their own data protection regime in a way at a contractual level. So that is quite useful, and it could even be that, for instance, the data importer is in a country where there are no data protection rules, and nevertheless the data importer might be willing to commit to ensure a certain level of protection contractually, and that can allow them to transfer data, whereas otherwise that would not be the case. So that is one very important role, I would say. It's also that these model clauses, because they are pre-approved, they I think they ensure legal certainty. Companies know what they have to apply in terms of data protection rules. It's not less than what is in the clauses. It's not more than that. So they know exactly what they have to do. So it creates legal certainty and predictability and transparency around it. And then, as I said, and that's, I think, another very important aspect, is that what I said about this being a low-cost solution, because companies do not have to negotiate these clauses, these safeguards in each individual case. They can simply rely on what has been pre-approved, and know that if they follow these model clauses, they are on safe grounds. The data can be transferred, and they are also safe from enforcement. And so because they are pre-approved, you don't have to negotiate them. You don't need a lawyer, a law firm. So it's low cost and in a way rather easy to use a tool. And that's, for instance, a big difference to a certification mechanism, because a certification mechanism typically requires a certification process, so a process whereby a certain body checks how you protect your data and maybe requests all kinds of documents, maybe even audits you. All of this takes time and is costly. Certifications very often cost several thousand euros or dollars, whatever currency you want to use. That's different for model clauses, because they are there. You basically take them from the internet and you plug them into your contract. You have to fill in the annexes, because in the annexes you have to specify a bit what exactly you are transferring, what type of data, what role you have, and certain, you might have to specify sort of what safeguards in terms of security you will apply. But that's all relatively simple and goes relatively fast and is not costly. So I sorry for being a bit long, but I thought that gives you maybe the overall picture. I cannot hear anything.
Peço desculpas, o problema que foi meu. Ralf, muito obrigado. O Ralf deu um resumo bastante interessante e até completo e complexo de vários aspectos fundamentais, não somente da modernização, mas de como são implementadas, de fato, as cláusulas contratuais padrão. E muitos pontos aqui mereceriam até aprofundamento se a gente tivesse esse tempo. Por exemplo, uma coisa que chama muita atenção, para mim, pelo menos, é que o mecanismo de adequação, que o Ralf mencionou na pergunta anterior, ele, a princípio, é um mecanismo de transferência internacional mais apropriado, no sentido de eliminar barreiras e fricção de uma forma quase que absoluta. Nesse sentido, ele é muito desejável em muitas circunstâncias, porém, obviamente, do ponto de vista regulatório, é o mais complexo e lento para ser atingido. Isso contrastaria até com uma característica que o Ralf ressaltou agora nas cláusulas contratuais padrão, que é o seu baixo custo, a sua praticidade. Elas, uma vez inseridas em contrato, tendo sido pré-aprovadas e garantida a sua especificação, elas podem, por si só, legitimar uma transferência de dados. Até, em algum momento, Ralf, depois, se você puder fazer um comentário sobre um aspecto que até esse baixo custo das cláusulas também ele enfrenta, eventualmente, pode enfrentar algumas questões da sua utilização prática, como, por exemplo, muitas vezes o ente privado que utiliza as cláusulas contratuais padrão, ele vai ter que fazer, ele próprio, uma espécie de verificação, de adequação do ordenamento do país ao conteúdo das cláusulas. Enfim, há outros elementos além das cláusulas que podem ser relevantes, e esse também é um custo em si. E aqui no Brasil, muito provavelmente, como em tantos outros países, uma grande preocupação é fazer com que esses elementos que legitimam a transferência sejam efetivos, mas também possam ser escaláveis. Isso é, não sejam instrumentos que estejam ao alcance somente de players, de entidades com maior poderio econômico, para que a gente possa abranger em todo o leque de diferentes estruturas econômicas e capacidades econômicas o respeito pela proteção de dados, reconhecendo ainda a importância de a gente ter esse mecanismo, os mecanismos de proteção presentes em todos os aspectos do tratamento. Mas eu queria aproveitar também para colocar uma outra questão, também referente à modernização das cláusulas contratuais padrão, que é o fato de que o debate sobre transferência internacional nos últimos anos, nas últimas décadas, foi sendo muito girou muito em torno dos julgamentos dos dois casos Schrems 1 e 2 para a Corte de Justiça da União Europeia, Tribunal de Justiça da União Europeia. Dois acordos de transferência internacional de dados com os Estados Unidos foram denunciados pelo tribunal. Isso, aqui, pelo menos ao meu ver, foi muito relevante em vários aspectos, fora aqueles óbvios, mas também para deixar muito claro que há um certo ceticismo em relação à proteção de dados talvez não fosse mais uma opção racional nem razoável. Ceticismo no sentido de que talvez alguns setores apostassem que essas regras não iriam ser levadas à sua plena efetividade, mas a verdade é que a sociedade pede maior proteção de dados, os reguladores estão atentos, os tribunais também. Enfim, há hoje em dia uma corrida para o alto em busca de padrões, ao que me parece, mais efetivos de proteção de dados, inclusive em relação à transferência internacional. E talvez, nesse ponto, as cláusulas contratuais padrão também têm um papel muito relevante. Eu queria perguntar para você, Ralf, qual é a sua visão sobre o efeito das decisões de Schrems, principalmente a Schrems 2, sobre isso e qual seria o papel das cláusulas contratuais padrão no mundo pós-Schrems 2?
Thank you very much on that, and I think I will get to this just because one thing that you mentioned that well triggered my thought that maybe I should also stress, of course, that model clauses are not country specific. No, so and so-called adequacy finding is country specific. So we have, for instance, recently adopted an adequacy finding for the United Kingdom, or we have an adequacy finding for Canada, or at least for data that is covered by their data protection law. We are prepared. We have adopted an adequacy decision for Japan, and we have prepared one. It's not yet adopted for Korea. So it's for an entire country, and of course it brings a huge benefit, because with respect to that country, you no longer need another transfer instrument. So, for instance, you no longer need to use model clauses or any other instrument. Whereas model clauses work differently. They as I said, it's a contractual tool, so they can be used by anyone, anywhere in the world. And this is maybe then where the Schrems judgment came in. So for those who are not following this, this is a judgment from our highest court in Europe, which is called the European Court of Justice, and it's a judgment which arose from a national court case, a national dispute in Ireland with respect to the transfer of personal data from Facebook Ireland to its headquarters in the United States, and that's why it has a partly, at least, a focus on the United States. It's simply because that was the underlying litigation, and it has the name Schrems because the litigant is a privacy activist who's called Max Schrems, who brought the case. So that's just by way of background. What is this case about? I think one has to maybe to step back a bit. The underlying objective of our data protection rules, but it's not just limited to Europe. We are seeing this more and more in other parts of the world as well, is the idea that since personal data is protected as a fundamental right, we have it in our charter, in our constitution, as is the case for many other countries. Because it's protected as a fundamental right, we have to ensure that the protections are not undermined when data is transferred abroad, because that's what's so specific about personal data. It can easily move from one place to another. It can easily be transferred, and at the same time, it is the object of a fundamental right. So it's trying to grapple with this very specific context, and of course the risk can come from different directions. The risk can come from the fact that maybe the data importer, like a private company that has received the data, for instance, to carry out a service, is not treating the data in the way it should be treated, is abusing, misusing the personal data. That's one of the risks. But another risk is, of course, that maybe the data is transferred and the company that receives it itself is actually protecting the data well, but then the government comes and either asks for the data or maybe directly even accesses the data. And this can happen in of course, a number of contexts, but let's say the most sensitive ones are probably where this is done for purposes of criminal law enforcement, so by the police or prosecution, or it's done by national intelligence, national security authorities. And so what our court basically has said is that this is also something that you have to take into account as part of the risks when data is transferred. Now it's of course clear that with and I'm coming back now to the model clauses as a contractual tool, you can of course not bind the government. It's a contract between two companies. between two private entities, the data exporter and the data importer. And the state, the third country government, is not part of the contract. So how do you deal with this? And basically what the court has said is that in this context, what the parties need to do is they need to make an assessment as to whether the rules and practices of government access in the third country, in the country to which the data will be transferred, whether these rules appropriately ensure appropriate protections for the data. Because it's, of course, our court fully recognizes that there are legitimate reasons for the government to access the data, but there should be limits around it and safeguards. And at least from a European perspective, what needs to be ensured is that data is only accessed if this is necessary, where it needs to be ensured that it is proportionate, so that the interference in a way is balanced with the objective that is pursued, and then there should be certain safeguards around it. For instance, the possibility to obtain redress against government access. So those are some of the elements that the court clarified in that judgment of last year, and so we have tried to reflect this to the extent possible in the model clauses. So the model clauses require an assessment from the parties that the law and practice of the third country fulfills these basic requirements, and they are really basic requirements, I would say, of a democratic country with the rule of law and respect for fundamental rights. It's not something extraordinary, but they are core requirements. And if it looks like there might be an issue, then the parties might have to take certain measures to, for instance, better protect the data. Perhaps, for instance, to encrypt the data, to protect the data against government access. And there are also certain requirements in terms of mutually informing, so between the parties, to inform each other if there are problems that arise with respect to government access. Certain requirements when it comes to maybe challenging a request for data in the third country. So the data importer, when there are reasonable grounds to believe that a request is unlawful, has to challenge that request. Not each and every request, but if there are reasonable grounds to consider that it might be illegal, unlawful. So there are certain obligations in the model clauses that try to address the situation of a problematic government access. So that is basically what the Schrems judgment is about. It is, on the one hand, it deals with the sort of legal standard for government access from a European perspective, but of course that is important then also for data transfers, because we have to ensure that level is not undermined in the third country. So it deals with those questions, as I said, necessity, proportionality, transparency of the rules that allow government access, redress, in particular judicial redress, in the third country. And then the second aspect is, how do you deal with this when you use a tool that is contractual? And I've tried to explain how we have addressed these issues in the model clauses. Maybe to say also that, and I said this at the very beginning, this is not just something that we in the European Union, I think, are struggling with. You will find something similar, for instance, I mean, first of all, model clauses are now also used in other parts of the world. It's actually a tool which is gaining traction. It's becoming more and more popular and relevant also in other countries and regions around the world. And if I give two examples, New Zealand has last year adopted also model clauses, which also address the issue of government access. So it's not just something that we are dealing with. And then beyond that, more and more countries, I think, are concerned about government access, in particular by government access by authoritarian regimes. And so there is, I think, a broader discussion currently ongoing at various levels. For instance, in the OECD, about what distinguishes legitimate government access from unlawful, disproportionate, illegitimate government access. And I think this reflects the concern that many countries around the world have when it comes to that topic. And you see also other countries, for instance, like the United States, that is taking more and more measures to protect its infrastructure, but also its data from interference by foreign countries, by authoritarian regimes, and I can certainly refer to many more examples. So this is a broader debate, and I think an important one. And I think the judgment of the Court of Justice has to some extent hasn't started maybe the debate, but it has certainly given it more visibility and urgency in a way, and that's why we are now seeing these discussions. And I hope that what will emerge from this is a set of guiding principles, global principles on government access that, as I said, distinguish legitimate from unlawful, disproportionate government access.
Muito obrigado, Ralf. Efetivamente, considerar os efeitos das decisões Schrems, principalmente a Schrems 2, coloca muito mais riqueza no detalhe na abordagem de como se enquadram as cláusulas contratuais padrão nesse esquema, que também inclui, como pano de fundo relevantíssimo, o acesso governamental a informações, um problema bastante importante e delicado, com o qual proteção de dados e outros aspectos devem se deparar. Eu gostaria de fazer uma outra pergunta. De certa forma, Ralf, você já mencionou vários aspectos em relação aos efeitos dessas cláusulas para países na região da América Latina. Mas, de toda forma, se você quiser acrescentar alguma coisa mais específico, e ainda mais lembrando que, sim, as cláusulas contratuais padrão não são um instrumento que vincula diretamente governos, mas, eventualmente, alguns efeitos indiretos podem ser bastante fortes em algumas situações. Dessa forma, considerando que hoje, ainda considerando a diferença desse regime para o da adequação, e que somente na América Latina, Uruguai e Argentina são países reconhecidos como adequados pela Comissão Europeia em relação às suas respectivas legislações de proteção de dados, como você observa o impacto potencial dessas novas cláusulas contratuais padrão para países na região, como Brasil, México, Chile, Colômbia, países que estão desenvolvendo com intensidade suas disciplinas de proteção de dados, e para os outros países da região? Há algum efeito específico que você destacaria como mais importante? E acrescentaria ainda um pedido para, se você puder comentar, já que você mencionou o caso da Nova Zelândia, que na sua legislação incorporou um regime de cláusulas padrão. Mas me parece que países como Nova Zelândia, até mesmo Singapura e outros, eles são, digamos assim, mais flexíveis no que eles consideram cláusulas padrão. Eles consideram a necessidade de alguns requisitos que estejam previstos nos contratos, não propriamente com cláusulas tão formalizadas. Você, Ralf, você enxerga uma possível compatibilidade com soluções talvez um pouco menos formais e mais flexíveis do que as cláusulas contratuais padrão para a América Latina, ainda que seja, obviamente, a nível contratual, e que essas possam ser compatíveis com os requisitos que a Comissão Europeia pode vir a julgar, considerar no futuro?
Okay, let me take these two. In a way, it's two questions in one by one. Yeah. I think the first question was the more general one. I think on you said the impact on Latin America. I mean, first of all, as I explained, these model clauses are one of the most important transfer tools from Europe. I mean, for the transfer of personal data from Europe to third countries, including, of course, Latin America. I think that is currently the case. This was already the case in the past, except for, as you say, the two countries for which the Commission in the past has adopted an adequacy decision, an adequacy finding, Argentina and Uruguay. As I said, if you have an adequacy finding, there is no need any longer to use one of the other transfer tools. So, but for the rest of Latin America, currently, as we speak, data is mostly transferred on the basis of contracts, contractual safeguards, and in particular on the basis of model clauses. And I think that will continue to be the case. We are, of course, hopeful that we will also eventually have adequacy findings for countries, for instance, like Brazil, which has now a brand new, very good modern data protection law, or Colombia, which already for some time has again a very good data protection law, and with whom we are indeed also have with Brazil and Colombia we have a very good exchange and cooperation. So I hope we will be able eventually, certainly if there's an interest, to work on an adequacy finding. The same I could see for Mexico, for instance, which has a very developed data protection regime. So there are some countries where we can go down this path, but in the meantime, and so in that sense, the urgency is not there. In the meantime, contractual tools can be used, and of course, if you have a developed data protection regime, it will make it much easier, of course, for companies to abide by, to comply with the obligations that they would undertake under the contract, under the model contracts, under the SCCs. I mean that is obvious, I guess. If you come from a country which has no data protection regime, what these clauses require from you will be new, and maybe you will have to adapt if you haven't used them in the past. But if you come from a country that where you also at home domestically in any event have to respect many of the same, if not all of the same obligations, then of course it will make it much easier. And I think that's the case, for instance, for Brazil or Colombia. Brazilian companies, Colombian companies, in any event, have to comply with a strict, I would say, data protection regime, a good data protection regime, which we believe is quite close to the data protection regime that we have in Europe. That's the reason why we think this could eventually lead to an adequacy finding. But in the meantime, it means that companies are familiar with these types of obligations, have probably incorporated them into their procedures, their processes, and therefore it will be easy for them to use these clauses and ensure compliance with them. So I think that's part of the answer. And then, of course, we would hope also that Latin America will develop similar instruments, or one similar instrument, because I think ideally this is not done on a country-by-country level, but perhaps at the level of the region, if possible. If not, that's also not a problem. But of course, since there is already a lot of coordination and cooperation across Latin America, I think it would be helpful perhaps if model clauses would be developed for the region as a whole, perhaps by the data protection authorities or through other forms of cooperation. That's just an idea, but I think it could be quite helpful. And then, of course, what would be even more helpful is if we see some convergence between those model clauses and the model clauses that we have developed. And that brings me maybe to the second part of the question, or the second question, because I think you referred to some other existing model clauses. I think, I mean, there's certainly the ones in New Zealand that are worth mentioning, which I think, well, they are of course different than ours. If you look at them, they may be structured a bit differently. The terms used are perhaps different, but I don't think they are so different on substance. So I think and maybe that's not surprising, because we also have an adequacy finding for New Zealand, which means that New Zealand law, which moreover has been just updated and modernized, is rather similar to our data protection law, and I think the model clauses reflect that. The other important area, geographic area, where you find model clauses is ASEAN, and I would say there indeed there are maybe some bigger differences, which I think has to do with the fact that ASEAN covers a large number of countries, and some of these countries are at the very beginning when it comes to data protection. So there are some countries that don't have a data protection law as of now, and some others that are maybe in the process of developing it, but it's not yet there. And then there's some which are much further ahead, such as Singapore. So I think ASEAN had to sort of bridge quite significant differences in their domestic legislation, and I think the natural tendency was therefore to maybe start at a bit of a lower level of I wouldn't say ambition, but I mean a bit of a reduced set of safeguards, and I think in that sense, indeed, there's a bigger gap between that and what we have. I wouldn't say this is therefore more flexible. I think it's leaner, it's more reduced, but of course that also means it provides less safeguards and less certainty for how the data will be transferred, because more is left to the domestic rules of the data importer. So only certain safeguards on data security, for instance, maybe on purpose limitation are regulated. Other things are left out. And of course, I mean, from a company perspective, perhaps some companies would want that. Maybe they don't want to comply with a more stringent set of obligations. But I think that's probably short-sighted, and I think actually more and more companies prefer to have a more complete set of safeguards, because they then use these model clauses in all their contractual relationships. And once you have adapted to these and built these safeguards into your system, I think it's then much easier to operate in all parts of the world. What I want to say is that if you start very low, it will only allow you to have data exchanges with certain countries and with certain other countries, because they have a higher level of protection at home. They will also require more for a data transfer, for data transferred from their jurisdiction to yours. So I think being at a higher level actually gives you much more reach in terms of your economic operations across the globe. And I think that is an advantage. And of course, there is the element of trust. The customers, clients, they more and more want to be sure that when they give you your personal data, that it's also protected when it's then transferred abroad. And that trust comes from a higher level of protection and more stringent rules, because the more loopholes you have, the more questions arise and the more scandals we see when it comes to the use of personal data. So I think in the end it doesn't pay off, and our, that's my last word on this. I mean, of course, we have modernized our model clauses, and on a number of points we have indeed gone a bit beyond what we had before, but it's not a radical change. There is a lot of continuity from the existing clauses, and these have been used for 15 years and without problems. So companies seem to be quite comfortable with those, and it has to do with the fact that they address basic principles of good data management, purpose limitation, limited data retention, giving certain information to individuals, granting them certain rights which very often are not exercised but should be there in case it becomes relevant. Certain questions around data security and so forth. It is not rocket science. It is, I think, those are basic requirements, and laying them down with some specificity is actually good, because then both sides know exactly what they have to do, and there's not there are no doubts about it. There are no questions that can arise and lead to litigation, or less at least. So there are also benefits of being more specific.
Muito obrigado, Ralf. Foi excelente a colocação. Na verdade, quando eu pensei em flexibilização, era mais no sentido de adequar as cláusulas a requerer um determinado efeito, num determinado ordenamento jurídico, e não propriamente no sentido de materialmente restringir obrigações, o que não me parece factível. A gente observa, por exemplo, exemplos são muito flexíveis, talvez, mas num sentido um pouco mais material, como da própria PEC, por exemplo, que tem dificuldades tremendas em comprovar efetividade e gerar confiança. Então, e nesse ponto também a resposta do Ralf me ressoou um pouco meu velho professor Stefano Rodotà, que dizia que a proteção de dados tinha uma vocação muito grande de operar o que ele chamava de globalização através dos direitos. Isso é, como o direito à proteção de dados era cada vez mais importante, mais sensível para as pessoas, havia uma tendência a que as uniformizações, as padronizações fossem feitas no nível mais alto e não no nível mais baixo. E esse é justamente o trabalho da Comissão Europeia nos últimos anos, nas últimas décadas, vem efetivamente comprovando na prática como uma política pública pode ter essas bases e alcançar alto nível de eficiência e influência. Ralf, eu gostaria agora de passar para uma ou duas perguntas. Recebemos algumas perguntas excelentes. Uma delas, eu confesso confesso que seria a pergunta que eu faria também nesse momento, mas eu não preciso fazer porque já veio pronta da plateia. A pergunta é a seguinte, veio pelo YouTube. Como são administrados os mecanismos de certificação? As entidades de certificação são registradas e controladas regularmente? Existe uma certificação oficial? Essa pergunta da plateia, e acrescento eu que os mecanismos de certificação chamam muita atenção no Brasil, certamente vão ter um potencial interessante, ainda mais levando em conta a dimensão do país e a necessidade de que mecanismos de transferência internacional sejam variados e atinjam um grande número de empresas que eventualmente vão estar interessadas. Ao que me parece, hoje em dia existem poucos, ou talvez só posso estar errado, só uma certificação reconhecida a nível europeu. Então, é um processo que ainda vai ser desenvolvido também na União Europeia. Mas, enfim, a pergunta é essa sobre certificação, Ralf.
Yes, and I think that's quite an important question. So happy to dwell a bit on this. So we have on the one hand introduced this tool of certification at the level of the European Union. We had certification mechanisms for a long time in Europe, but it was at national level. So at the level of our member states, like Germany or France. And with the GDPR, we have introduced it as a tool which can be also for the entire European Union. So a certification which allows you to be used across the European Union, and that's a further sort of new element which was introduced also as a transfer tool. So that didn't exist in the past, and for this second aspect, however, it requires to working out a bit the sort of the infrastructure of this, and I think the question is quite pertinent on some of these elements. So this is something which is currently still taking place. Some guidance documents have already been adopted, both on procedure and on substance. On substance, I mean the certification criteria. But there are certain elements which are still being developed. But I think within the course of this year, this will also be it will also be possible to use it as a transfer tool. It already exists for within the European Union. And when it comes to so more specific to your questions, the certification bodies under our rules can be two different types. The data protection authorities can be certification bodies, but beyond that, there can also be specifically certified bodies that act as certification bodies. So, what this means is not anybody can act as a certification body, but you have to be certified as such, and that requires that certain checks are carried out, whether this body is independent, whether it has the knowledge and expertise to carry out this function, whether it has the budgetary means to do so, and so forth. So there are certain criteria that need to be fulfilled, and then there is a certification by an official one of an entity as a certification body. So that's in terms of who can do that. And then, of course, there are requirements as to what these certification bodies have to do in terms of what they need to check at the beginning when a company is certified, or what they have to do in terms of monitoring, and how they have to intervene if a company does not respect the certification and so forth. And then there's also, because I think there was also a question on how do you recognize actually that a company is certified, and there is the possibility of a and I was trying to find the exact word. I think it's called the European Data Protection Seal. So there would be a logo in a way, which would be given and which can then be used by companies in their public appearance on their website to show I am a certified company. So that's quite important in terms of where we are with this and how it will work. But as I said, some of the details are still being worked out because, for instance, there are certain questions around how do you ensure that individual rights can be enforced. Because it's one requirement under our rules that individuals must be able to enforce their rights to access, to rectification, to correction, and certain other rights against the data importer, against the certified company. And so we're still having some discussions around how to best ensure that. That's one of the elements, but most of them are there, and I think we will by the end of the year see the first. I mean that this process of preparation is completed, and that then companies can be certified.
Obrigado, Ralf. Esse processo certamente vai ser seguido com aqui na América Latina, com tantos outros, porque a minha impressão é que o procedimento de certificação, selos e programas de qualidade serão muito relevantes também aqui e devem certamente ganhar muito em serem compatíveis e interoperáveis. Nós temos 4 minutos, eu vou fazer uma última pergunta que eu também confesso que é uma pergunta que eu tranquilamente faria, até porque ela está ligada a alguns pontos da fala do Ralf. A pergunta é: poderiam as autoridades de proteção de dados cooperar internacionalmente para redigir cláusulas contratuais padrão que sejam interoperáveis para utilização em contratos envolvendo vários países diversos? Essa é a pergunta, e aqui eu faço uma menção direta até o que a sugestão e observação que o Ralf fez, ao meu ver, com extrema pertinência, de uma eventualidade de termos cláusulas contratuais padrão no âmbito da América Latina, no âmbito da região. Isso seria, claro, um desenvolvimento muito interessante a ser levado adiante, que pode ser o resultado de uma futura cooperação entre as autoridades de proteção de dados da região. Eventualmente, a própria rede ibero-americana de proteção de dados pode ser um fator indutor em conversas desse tipo, eu não sei, mas de toda forma seria um avanço bastante interessante para as autoridades de proteção de dados, mas também para toda a proteção de dados da América Latina, ao meu ver, e a sugestão aqui foi plenamente anotada, claro, mas gostaria de saber também o que o Ralf tem a comentar sobre a pergunta: qual o papel das DPAs nessa possibilidade de ter cláusulas regionais padrão?
I think ideally they should be in the lead for this. I think they are best placed to work on such clauses because they know what what are the risks that data protection has to address. They know their data protection frameworks, of course, and of course, I mean, this, if it's done at regional level, it will mean that to find a compromise, to agree on clauses that sort of bridge across potential differences that exist in the data protection rules at national level. But also there, of course, since the network, the Ibero-American Data Protection Network has already developed the Ibero-American data protection standards, they have in a way already done that work. They have already harmonized in a way, developed harmonized rules for the entire region. The model clauses, of course, don't have to incorporate all of this, but they can take from that the most important elements, because that's what you do. It's not the entirety, but it's the core, the essential elements, and they can draw from they could draw from these Ibero-American standards, and so I think, because that work has already been done, I think they would be in a very good position to work on such clauses, and bring their knowledge, of course, also from the enforcement side with it. They know best sort of where are the issues and the particular risks that need to be addressed. So I think, the process in Europe was a bit different. The law gave the competence for developing the model clauses to the European Commission, but we were required to, and we wanted to work closely together with the data protection authorities. So this is a product which builds a lot on input from the European Data Protection Board. So also there, because they know best sort of what are the critical issues, and they know from their enforcement sort of maybe what pitfalls, what challenges to avoid, and so yeah, by all means, I think if this could be done in Latin America at that level, I think it would be wonderful. Would be an excellent idea.
Então, é muito interessante. É claro que os estándares, os padrões ibero-americanos foram feitos no espírito de procurar harmonizar, inclusive incentivar países na região que ainda não tinham suas próprias leis a trabalharem nesse sentido. E hoje, talvez, as cláusulas contratuais padrão na América Latina possam ser uma nova pauta, um novo passo desenvolvido a partir dos padrões da rede ibero-americana, mas que pode denotar já uma aplicação bastante prática dessa estrutura que é a rede ibero-americana, ou de outras estruturas que possam vir a ser criadas. Ralf, eu gostaria de agradecer imensamente, foram 90 minutos muito ricos. Esse tema certamente só está começando a ser tratado com profundidade aqui no Brasil, e em vários outros países da América Latina já há mais trabalho sobre isso, mas será muito importante para toda a região. Esse vídeo vai permanecer online e certamente será a fonte de consulta e vai trazer muitas outras indagações para as quais nós esperamos voltar a contar contigo, com todo o Legislativo, com a Comissão Europeia, para que possamos desvendar novas etapas desse trabalho. Gostaria de agradecer à Fundação Getúlio Vargas, a equipe do CPDP Latam, que está toda aqui, o Walter, que preparou aqui as perguntas, excelentes perguntas, agradeço a quem as fez, não tenho os nomes, infelizmente, mas agradeço muito, e aos intérpretes, agradeço também à Comissão Europeia pela disponibilidade de ter com a gente esse evento, que vai ser muito importante para nós brasileiros, latino-americanos, e com isso eu encerro essa rodada de bate-papo com o Ralf Sauer e agradeço a todos, espero que nos vejamos em breve.